All right. Let's see. Am are we live? Okay. The water over here. Juice. Where are we at? Charger here. All right, all right, all right. Peace to the gods, peace to the gods. I had a troll on Instagram. I'm gonna have to start putting lawsuits on some of these cats. Cat just appeared out of nowhere, started talking about a whole bunch of unrelated shit. I'm like, this don't have nothing to do with me. Peace to the gods. What's up? What's up? I'm gonna let everybody get in. I'm gonna let everybody get in. Let me see where we at. Oh shit. Hold on for a second, y'all. I gotta. All right. Okay. Sorry about that. I had to change my bit rate real quick. I'm learning how to do this streaming thing pretty good now. There we go. There we go. It was good. It was good. Okay. All right. How does that look? That look pretty good. Excellent. All right. Excellent. All right. What am I doing with the keyboard in the background? This is a MPC Key 61. I have a studio. A young, I used to own a recording studio back in the 90s. So I've always been into the music industry a little bit. But I'm going to make some beats with this. I'll get into making some beats and everything. I like music, and I'm teaching myself, practicing my piano and my keys and things like that. So uh, this is a nice machine right here. I've had this for a minute. If I had this thing, I've had this thing for a minute. But I just decided to, I built a new studio and I just added it into the studio. So that's what I'm doing with that key. It said, do I play? It's not for show. It's not for show. Now I'm learning how to use it. I've never used it. I've never used this type of MP before, but it's got the keys on it. But I like beats, man. Y'all see all the stuff I put out have beats in it. I love beats. Love music. This kind of music they playing today, though, is kind of, something else. Peace, praying much for the world. Okay, what I'm doing today, I'm going to talk about what we teach at SPC University. First of all, first and foremost, I hope everything is nice and clear, good audio, everything is good. All right, I got a couple of things I want to talk about. And I'm going to start every show talking about it. First and foremost, I want to talk about let's see. What happens when you register at SPC University? Man, where is it at, man? I just saw it up here. Yeah, where is it? Okay, there it goes. All right. All right. All right, so this is SPC University, all right? I gotta get some things clear. This is SPC University. I don't really teach secured party that much anymore. We still have the videos over there. We've even changed the meaning of SPC. We are into trust and private ordering and contracts, all right? Let me get that very clear for a lot of people over there because they don't seem to understand that, all right? We're on private ordering. We're in the age of AI. We're in the age where you can verify information. I don't teach right to travel. I never have taught right to travel. And y'all know within the last year, I've really been going hard against right to travel, okay? If it cannot be substantiated, we don't deal with it. All right, so real quick, when you enroll, all right, these are our membership prices. We are $99 a month. You can get 3 months for $250, or you can get a year for $997. The more you pay, the more, of course, the less that it costs. These prices will be going up to around $3,500, all right, because that is the type of information that we are teaching at SPC University. So it'll be wise for you to get in now. All right, now, what do you get when you come for this money that you're paying for SPC University? Okay, let's take a look at that. Let's see, what are you getting for that? All right, so let's log in. Here's the login page right here. All right, when you log in, okay, and here's our dashboard. All right, so it's a dashboard. And down here is the academy. The academy over here on the side, okay? Now, we have courses. I'm redoing the courses and everything, but I'm going to start with what I am focused on right now, and that is the webinars, all right? These are the webinars that we have been promoting so far. So right now, this is the, we have private irrevocable trust for the series of August. So when you come in here, you just click join, and this is going to take you into the webinar, okay? As you can see, there are the dates. We got a class tonight, all right? So we got a class tonight on the 20th, 25th, and 27th. This is just for the month of August, so it's 3 more classes for the month of August. Every month, I post classes, okay? So we do live classes. Also, you know, we have past webinars on private trust. Obviously, you can go to all our past webinars, and you can catch those as well. Well, this is a registration right here. It's right over here. Go over here. Our academy again. We go to our courses over here. And in here, this is where you find like all my old archive of videos. Like a lot of y'all might be interested in GSA bonds and discharging criminal cases and suing the debt collector, and filing the UCC1. And, you know, there's my Dr. Delbert Blair interview that they won't let me put on YouTube. Commercial security agreements, registered mail forms, copyright clearance, UCC1. Those are all old webinars. Now over here, I got a lot more too than this. Over here, we have right here, and then the courses. Now, if you are still interested in secure party, hold on. I'm sorry. If you're still interested in that, we also have, go to courses right here. All right, they're going to 22 days of business trust. Let me put that up. This secure party right here. All right, and then you see that we have 22 separate videos showing you how to do secure party. Start with introduction, UCC search, commercial and community agreement, copyright clearance, what all this means, which I do think that people should understand this because a lot of you are interested in this and you should understand it. So when we start modifying it, you can understand why the changes are made. But it should take you a little while to go through all of these. All right, then we have Academy, back to our courses. Of course, I have my 22 business day. Now, people love this. There's so many people love this series. They just really love this series. But it's 22 days of business trust. And this is when I really, first time I started teaching trust. When I very first started getting into it. And as you can see, a lot of the webinars are 3 hours. And that was just day one. And I went through 22 days, and we went through trust administration. The document I taught from was a document that I got from an attorney who puts together private irrevocable trust. And there's tests associated with this too. When you get through, there's a test that goes with it as well. All right. Let's go what next? Go back to the academy. Go back to the courses, and you see negotiable instruments. This is our archive. You know, I've taught negotiable instruments so much. Creating a bill of exchange from scratch. He says 2013. You know, that's the only one I put up. But that's like one of my very best videos on creating negotiable instruments. Very good. Okay. Let's go back. And you really have access to everything that I've ever taught. You know, I've done a lot of webinars over the years. And so when you become a member, I just give you access to all of them. All right, so we also have archive of old webinars. Wait a minute, I just showed y'all that. Okay, I just did that one. Where is that? Right here. Negotiable and how to use the site. These are live webinars right here. So, understand. No, that's not it. Hold on. That's for status correction. Those status correction webinars. Right. Right. Oops. Ultimate status correction, sneaking in the movies. Yeah, I think it's it right here. Ultimate status correction. All right, you can see right here. Okay, these are all videos on status correction. We add these videos as we go in. And I kind of just left up the ones that I think that are very, very pertinent for you to study. Then we also have a PDF reading room. This right here is all of a lot of the stuff that we have been developing over here over amount of time. All kind of documents. Of course, you got dictionaries, American jurisprudence. That's a lot of different things. Course modules. Yeah, this is the course modules folder. Module 1, is that? No, that's not it. 7 days. But each one of these is like, you know, we got credit. We have, of course, this is in private trust. This private trust folder is the one. all the case law, the bankruptcy cases, but you're going to need to kind of come to the classes to really learn how to use this section right here, because these are different clauses in trust. Like here's the case law dealing with trust. These are cases dealing with self-dealing, things of that nature. I just got everything separated into different type of folders for you as they relate to trust. So I got them all broken up. And it's a lot of different books on here on different things like that. Then, of course, you got all your reference material as well. Here's our download materials. Now, download materials, this is going to be the crown jewel of SPC University. This right here is all of the information that you are really going to need to really understand private ordering. Now, this right here is one that's very important. It's litigation roadmap. If you're really interested in discharging debt, I really think you need to start right there, because that right there is getting into whether or not you have a right to discharge debt. I want to start with that real quick. Private administrative process is not magical. Status correction manual. And just give you an example of what this looks like. These are manuals. It's 105 pages. This one right here was an excellent document. 7 principles, start with that. But this is a status correction manual. This is our mission statement, acknowledgement. And all of our documents are like this. And this is what I've been primarily working on a lot. How to use a manual. I put weeks and months. I put a lot of time into this right here, a lot of research. And master table the meaning of status in real law, distinguishing mythology from jurisprudence, jurisdiction as a function of domicile, political status versus civil status versus commercial statutes, overview of the SPC University model, federalism and dual sovereignty, the 3 United States, constitutional, territorial, and corporate. This is coming from case law. All right, this ain't echo chamber stuff. This right here, you can substantiate it. Nationality, allegiance, and political status, commercial status. It's just a table of contents of what's in this manual. And we have other manuals like this. This is our Lux Ferris Trust that we're working on, but right now we're going through a lot of trust case law, right? I'm taking them through a lot of state law. Affidavit of status of identity, the Armand Condo letter, or auto loans actually fraudulent. Public versus private case excerpts. Personal jurisdiction and minimum contacts. Patriots versus anti-government. Gatekeeping. Express trust under the common law. A birth certificate authentication. I just went through everything that everybody's out there talking about. This is private member association versus unincorporated private association. Public versus private, what it actually means. Right to travel, DUI, passports and the right to travel, basic family trust, nationality, what it is and what it's not. 50 important legal terms for beginners. Recognize legal capacities. This is a big one. You need to know. Recognize legal capacities. Copywriting biometrics. Common law framework. Exchanger versus fund. Capacity, jurisdiction, and emetic framework. The language trap. Certain words you use. Equity is a remedy, not a hack. Private administrative process. The overturning of the Chevron. Everybody was talking about that case. U.S. Constitution protects privacy. That's exactly what it's for. Master legal analytical framework. Evidentiary procedures. Now, none of these documents are documents you find on the internet. None of this, you ain't going to find none of this stuff over in whatever that website is or whatever, All of this stuff is original content, original to SPC University. We're kind of changing. What y'all are seeing is I'm shifting over from the old model of what everybody was teaching, that all the patriot stuff that we were being taught, over into a new model. All right, on the way home so I can lock in. Okay, so I kind of wanted to just give y'all like a brief. That's not everything on the website. Obviously, I'm going to show you everything. But I kind of wanted to get you a feel of what SPC University is like. We do live webinars. Now I'm gonna say something too. I'm looking for teachers, people who can teach as well. I don't want to be the only teacher on there. So if you are an individual that is looking to teach and you have a specific subject that you are interested in teaching, I'd like to speak to you, and we could probably put you on the platform, and then you can teach your courses over there. We already have everything set up for you. The ability to do the webinar, all of that is laid out. All you have to do is show up with your curriculum and teach the subject. But that I wanted to kind of make you understand that, because it seems to be a lot of people out there that don't understand what we teach at SPC. I just got into it with a dude on Instagram. You know, this cat is on my Instagram talking about a whole bunch of more shit I'm not even associated with, and then trying to slander me. I'm about to put a lawsuit on him, because I'm getting tired of these guys coming in slandering me. I mean, just outright slander. Just outright slander. Next, I want to say this. Please do not come on my social media websites talking about, you know, I can't log in or something like that. Okay, listen, we have a customer service. When you come over to SPC University, all right, let me put it back on the screen so y'all can see. All right, this down here, you see this down here, it says chat with us for free online down there at the bottom. Let me see if y'all can see it. Right here on the front page. All right, if you got a customer service question, right there, we've had that over there a year. You type that in. If the chick does not answer that chat, I'm gonna fire her, okay? So you gotta be very careful when you say, if you want somebody to lose their job. We had somebody today say they contacted, she can't find a record of this dude nowhere. He came in with a fake profile. We found out who he was, all right? And I dismissed him from the website because I don't want anybody like that on my website, okay? He don't even need to be a part of my community, all right? But right here, if you have a question, all you have to do is type that in. If you can't log in or something like that, she is very, very proactive. She will contact you. She emails you your information. She has helped a lot of people. This has been on our website for about a year. Okay? So you don't have to contact me. You don't have to email anybody. You don't need to call anybody. If you have an issue, right there, that is where you want to go. We're updating this website also as well. We updating the entire website. Again, I got a crew right now. But that is where you go if you have a customer service issue. Do not come to my social media with a customer service. I am not customer service. I pay people to do that. I don't do that. I don't like that. That is inappropriate. We pay people to do our customer service. We got a lot of information that tells you what to do. And there's no excuse for it. If you type something in there and she doesn't get back with you, or one of our people don't get back with you, I'm gonna fire them. They understand how I am. But please don't come on my social media talking about I can't log in. Don't do that. Don't do that. I'm not customer service. I'm not customer service. All right? I'm not like that. Let he know I'm on. I gotta get a new phone. I gotta get a new phone. I gotta get a new phone because I got an S24 and an S25, and they too slow now. It's amazing how the technology, as it gets better, I'm getting used to it. But anyway, I just wanted to kind of put that message out there, because a lot of people, they'll come in and say, well, we don't have any record of that. We don't have a record of you trying to contact customer service, because this thing right here leaves a record. It sends all of us an email. We know when you have attempted to get in contact with us with customer service. So I would appreciate it if you go through the proper channels first before you start I'm at the top of the food chain. You don't have direct access to me. You don't have direct access to me. Oh, one other thing. With the consultations, we have a consultation calendar. You have been instructed, do not send me any money. I've been saying this for about 5 years. You schedule a consultation, you put on the calendar. Once your consultation is approved, we will contact you for you to forward payment to us, and then we will conduct the consultation. But you just sending me some money and saying I paid you for a consultation, I consider it a donation. You've been put on notice. If you send me some money, all right, and I didn't request you to send me any money, I got right here on my website telling you how to do it, and if you don't do it, I consider that to be a donation. Okay? You're not going to force me to have a consultation with you. Please go through the appropriate channels. And if you have an emergency consultation, it is $500. If you just want to immediately talk to me. All right? Is everybody clear on that? I hope everybody's clear on that. Let me show you where this is at. So people, up here it says, there's our booking right up here, you say home, you got consultation right here. All right? Consultation, $500 per hour, payment accepted, payment accepted. This is not customer service. Customer service portal is open, blah, 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 blah. Text an email. All right? Do not submit payment until your consultation is confirmed. Consultations are held, that's what we held, Monday through Thursday from 11 a.m. to 7 p.m. Payment is accepted through Zelle, Cash App, PayPal, and Venmo. All right? So please don't do that. You know, if you need a consultation, I don't mind doing consultations for you. But what I don't like is people kind of force me to do a consultation by sending me some money and then trying to act like I'm stealing money from you or something like that. And I didn't even know you scheduled the consultation because you didn't put it on the schedule. You just sent me some money and it went into my Cash App. And then you start talking about, well, you know, I scheduled the consultation. You didn't leave a phone number or nothing. I don't even have a way to contact you a lot of times. I've had people send me money on Cash App. I don't even know how to contact them. I don't even know how to contact. They didn't put a number in the message or nothing. I'm like, who is this person? Don't know how to contact you at all. So I just had to put that out there like that, okay? She reached out within seconds to solve my account issues. I have a client arriving and I need to go. Peace. All right, 333. I want to be a part of mob or private ordering. Okay, get out to public. Okay, you want to teach? That's fine. I have a client arriving. 333. Okay. All right, so let's see what we got here. So I guess I'm going to have to I'm going to have to start, before I start every show, kind of go through that, because it seems like it's a lot of people that don't understand some things, what we teach on SPC University. I mean, this guy just came on my Instagram talking about something 12 years ago or something like that. Hey, let me just say this to you. I don't know if what I did to you 12 years ago or 10 years ago, if you're still upset, but that's what women do. You're holding a grudge from me. I've moved on to other things, and I'm really not. And let me just say something else too, because when you start attacking a person's business, you know, you barking up the wrong tree, my guy. If you're looking at me right now, you out of pocket. You probably not. You say I'm fat and everything. Yeah, I'm fat, but I get women. You don't, obviously. You're not fat and don't get women, all right? And I think that's your issue, that you don't get any women or anything like that, you know what I'm saying? I just think that, because what man has time to do that? But I encourage you to go out and start making some videos about me. I like that when y'all do that, because that draws a lot of attention to me, and I need the attention, and that's why I was giving you all the smoke today. I want you to get out in that corner and go in and start promoting me like you should. Because obviously, and I am going to press a lawsuit against you because you sit here slandering me with stuff that's totally unrelated to anything that we teach on SPC University. It's totally unrelated. Totally unrelated. All right, so let's get to the question. Let's get to the lesson today, because I didn't come to talk about any of that. What I did come to talk about is the common law. Common law framework. All right. Let me see if I can put this on. I need to put this on. I think I need to put this over here. Yeah, I think I'm gonna put this over here so I can see it. Right here, yeah. All right. All right, we good? I had an issue with the ghost, and you was on point as always. I know. And why I'm excited to join God, and I appreciate that. I appreciate that. Because I appreciate all of y'all. I appreciate it. All right, let's see. All right, so let me, I think I can stretch it out like this. Yeah. All right, so here's an example of what we teach at SPC University. This is the common law framework. Now, the reason I'm doing this is because there's a lot of individuals that do not understand anything about the common law. All right, good, there we go. Common law framework, that pretty good? How's that look? That's pretty good, everybody? Pretty good. It's pretty good. Let's see. I look good. All right, all right. I appreciate it. I appreciate it. I appreciate y'all in the chat saying all the things that you say. You know, let me say this too. You know, sometimes when you get real popular, you can't, it's really, you know, you try to help as many people as you can, but when you're one person, you can only do so much. That's another reason I started a school. You know, I got, man, if I show you the backlog of people that want to just do consultations with me, I don't even engage everybody in a consultation, you know. I really don't have time and different things like that. But it's like, it's not because I'm trying to be malicious or something like that. It's just I'm one man, and it's just almost impossible. You know, I do got a life outside of this too. Or at least I try to have one. But anyway, let's get to this. Let's get to this document. Okay, this is something I put together for our university, the Common Law Framework, Foundations, Classification, and Courtroom Application. Foundation before remedies, posture before position, substance before form. I actually made this for YouTube. Okay, I made this for the SPC University for YouTube. And I made it for YouTube because there seems to be a lot of misunderstanding about what the common law is. You know, you hear people say, well, they're not operating under the common law. What does that mean when you say they're not operating under the common law? What does that mean? We've said they're not operating under the common law. Let me give my disclaimer first. This revised edition is an educational publication of SPC University. It is designed to teach legal classification, constitutional structure, common law history, remedies, procedural posture, and research discipline. It is not a substitute for advice from a licensed attorney who has reviewed the facts governing law, local rules, deadlines, and procedural posture of a particular matter. And we have to do this now. I don't know if y'all understand this, but you're on YouTube, you got to do stuff like this now. Court rules differ by jurisdiction. Federal rules cited in this manual are used to illustrate general procedural concepts. They're not automatically controls. They do not automatically control state proceedings. Personal jurisdiction, service venue, jury entitlement, preservation, appeal deadlines, and available remedies can vary materially by forum. The prior edition uses a Sixth Amendment framework to analyze some private rights and civil jury questions. This edition replaces that framework with two distinct tracks. One, criminal prosecution analysis under the Sixth Amendment, including the criminal versus civil classification of sanctions. And number two, civil jury/public rights analysis under the Seventh Amendment and Article III doctrine. The distinction is central to the revised teaching method. SBC rule. A strong legal argument begins by identifying the kind of proceeding, the source of the right, the nature of the remedy, and the procedural posture. Labels are a starting point, not a substitute for analysis. Because too many people in the echo chambers, they go by labels. I'm a private American citizen. I'm a Moorish American national. I'm this. That don't mean anything. Not by itself. And definitely paperwork doesn't constitute the matter. All right, let's get in this. Okay, preference, what this edition is designed to fix. The purpose of this edition is not to abandon the original teaching framework. It is to make the framework legally cleaner, easier to teach, and safer to apply. The central insight remains valuable. The absence of a private injured party can help classify a proceeding, but it does not automatically deprive a court of jurisdiction. A lot of y'all say, we're the injured party. Saying where's the injured party doesn't eliminate the jurisdiction. It just tells you what jurisdiction they're not operating under. Okay, you're not eliminating jurisdiction. Also, let me make something clear. Because people say, well, they try to use your teachings. I didn't teach any of this, okay? All this has been around for years before I came on the scene. When I come in and say, Yana, I request, if I come in and I say this, I say, is this civil or criminal? This is criminal. Thank you, Yana. Okay. It's okay if you go into court and I say, and you're in you're in arraignment, and I say, Your Honor, before I enter a plea, it is my understanding that pursuant to the Sixth Amendment for the Constitution of the United States of America, I have a constitutionally protected right to know the nature and cause of this action. Is this not correct? Yes, it is correct. Okay, I have another question for Your Honor. Okay, is this civil or criminal? It is criminal. Thank you. Let the record show that the action is criminal action. Now I have another question, Your Honor. The Constitution for the United States of America only grants this court two criminal jurisdictions. One is under the common law, and the other constitutes a condition of contract and the criminal aspects of a colorable admiralty jurisdiction. Under which two of these jurisdictions is court trying this criminal action? These fools will say that doesn't work. What do you mean it doesn't work? You're not asking that question to get the case dismissed, fool. You're not asking that. You're asking just what the question is. Is this civil or criminal? Because if it's criminal, it's taken care of one way. And if it's civil, it's taken care of one way. You're not asking the question. They'll come in and say, this doesn't work. What do you mean it don't work? It's a constitutional question. I tried that in court, it didn't work. That letter written to the Pope to Obama was fake. I don't know why y'all keep talking about that. Man, that letter written to the Pope, I know about that shit. What, that was about 5 years ago? Y'all just come with this bullshit. What does that have to do with America? That didn't have anything to do with anything. Y'all worship the Pope. Y'all think the Pope have some sort of authority over you? They think the Pope have some sort of authority over them. But this is what they'll say. Let me show you where that came from. Now, I've told you for the last, 15 years, this is the document this comes from, right here, Court Survival Guide. Let's see if I can download it real quick. Put it on the screen for you. All right, this is Court Survival Guide. All right. Let's get into this real quick. This has been around, I don't know, when was this published? This was published in 2008. And this is revised edition 2008. And One Man Out has it in there, and that came out like 2003. So I want people to understand that this terminology that we're using, it's been around over 20-something years. I didn't make it up. It's not my teaching. I've told you in the beginning where it came from, but nobody reads anything. You want to try to say we charge you money for stuff? Yeah, we're going to charge you money for things because you don't want to read yourself. Okay? I got a website right here. Top 10 documents. Uservale's top 10 documents right here. He did this, but I don't know, I think he did this back in, when did he do this? I don't know how far he did it. But right here, this Uservale top 10 documents. Right here. Creditors and their bonds. Dealing with presentments. What does acceptance for value mean? Gene Keating transcript. Gene Keating's prison treaties. Securitization. Court survival guide. Nature of the remedy. Zero out your account. Paper error. This ain't even my website. This is somebody else's website. This has been on the internet, I don't know, what, 7, 8 years? Or something like that? Okay, I just want to show you this, all right? Because people say, well, your teachings, and what the dude was trying to say, he said, well, he followed your teachings. No, he didn't, because I've watched everybody on the internet try to do this, and nobody, I haven't seen a single person do it right or understand what its purpose is, even though right here is a book that explains it. All right, written back in 2008. It's December 8th, 2008. All right, let's go through this manual real quick. All right, don't let the judge or the prosecutor get away with interrupting you. Okay, has the court made a judicial determination that I'm not allowed to defend myself or that I cannot have freedom of speech in this courtroom? Learn to nullify the judge's lame excuses. Well, I don't have it, the law or evidence in front of me. Okay? More lame excuses. I'm sorry, you'll have to talk to your legislators about that, as I only enforce the law. Or you'll have to talk to a licensed attorney about that because I can't give you legal advice. Or this is not the proper form, or that issue is not relevant to the case. These are things he's telling you judges will say. So here are these are some award-winning comebacks right here. Award-winning comebacks. Your Honor, I'm not contesting the law as you suggest. I'm merely demanding that you interpret it according with your own oath of office, and I'm asking you to do your job as referee and to identify the source of law you are interpreting. Now, please answer the question. Your Honor, you and I both know the legislators and you are all part of the same legislative branch operating provisionally under Article 1, Section 8, Clause 17. And there are no legislators here to identify the law and arbitrate a fair case. This is your job, and I'm simply asking you to do your job. Now, please answer the question. 3, Your Honor, I'm not asking for legal advice. I have my own legal counselors for that. I'm simply asking you to kindly identify yourself, the court's legal jurisdiction, and the nature and cause of the accusation. I'm asking you to identify the code of written law which supports your ruling. I'm asking you to do your job. Now, please answer the question. Okay, here's another one. Your Honor, if this is not the form for addressing the issue, then how can you now legally apply the issue for the first time in this case? If this is not the proper form, then I motion the court to provide the form required to resolve this issue before we proceed. I didn't write any of this stuff up. This shit has been around for 20 years. I don't understand it. It's been around for 20 years. Let's go, let's keep going. Let's get down here some more. Facing the judge and prosecutor attitude check, the sequence of court appearances. Now I'm gonna tell you what happened, how I found this document. I'll tell you a little story. When I was going through my ordeal, the prosecutor had found dealing with presentments and creditors and their bonds and all of that stuff. And she had sent it to me in the mail to let me know that she had it. And so I had to switch up. I said, you know what? They're going to be ready for me with all that information and those documents. So then when I got this document, I came in there and did a 360 on. They wasn't ready for it. They weren't ready for anything. They weren't ready now. I'm not saying that they aren't today, but back then they weren't ready for almost anything. And this is, I'm talking about federal court. They weren't ready for any of it. They were thrown off. All right, so if you go down here also, okay, here it is right here, steering with questions. Now that the judge has agreed to answer your questions, he or she must answer all of them until you're satisfied that you are fully informed of the nature and cause. If she or he tries to back out of the decision, then you must point out that the agreement has already been made and you intend to keep it. Start with a simple and indirect question about the nature and type of the type of the case. You will lead the judge into a corner. Question 1, is this going to be civil action or criminal action? If the judge answers that it is a civil action, not likely, then you must immediately object and then move for dismissal. The reason here is that you are now in the wrong court. The state cannot bring a case against you and the judge and judge its own case. It cannot be both party to and judge of their own action. On the other hand, if the judge answers that it is a criminal action, most likely, then you can make the following announcement on the record. Thank you, Anna. Let the record of this court then show that this action against you is a criminal action. Now I have another question. Question 2. Your Honor, the Constitution grants this court 2 different criminal jurisdictions. One is a criminal jurisdiction under the common law, and the other is a criminal action that constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Under which of these 2 jurisdictions does this court intend to try this criminal action? You see, I got it committed to memory. Not wanting to answer this, the judge might just dismiss the case now, but most will still try to go ahead with it. The only choice now are to admit to which jurisdiction applies or to avoid answering. Get an answer. If the common law criminal jurisdiction were to be declared, then you win by default of no sworn complaint by an injured party and no injured party present. There's no evidence at all of you interfering with anyone's life, liberty, or property. The case must be dropped. If instead the admiralty criminal jurisdiction were to be declared, foolishly, they're not going to do that, then you must be prepared to follow alternate plan B below. Therefore, most likely, here's where the judge will probably start squirming and just try to avoid answering by advising you to get a licensed attorney for such legal advice. So here's where you would make a stand by saying, thank you, Anna, but I don't think that you'd be violating your oath of office if you did your duty under the Constitution. You see, I'm not seeking legal advice. What I want to know is your legal intent. And I have the right to represent myself in my own person without a licensed attorney. And in order to intelligently defend myself, I have to know the jurisdiction that this court is operating under, because the rules of criminal procedure under a common law jurisdiction are very different from the rules under an admiralty jurisdiction. I need to know which jurisdiction you intend to try me under in order for me to proceed with this case. Now, the 6th Amendment grants me the right to know the jurisdiction being applied, and it grants you the duty to inform me. And I don't think you'd be violating your oath of office for doing so. So please answer the question. All right? The judge might dismiss the case here, but will probably continue stalling. He or she is likely to reprimand or threaten you for not getting a licensed attorney. The judge will imply that only licensed attorneys have this information, that you have to go see a licensed attorney in order to get the question answered. When this happens, say, thank you, Anna. Let the record of this court show that I, Yusuf Vail, the accused in this criminal action against me, have asked this court to divulge the nature and cause of this accusation under the authority of the 6th Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action. Furthermore, let the record also show that this court intends to bring this criminal action against me under a secret jurisdiction that is known only to the licensed attorneys. Oops, here's where a lot of judges will dismiss the case for whatever phony excuse. But there are still some diehards asking for more embarrassment. If the judge is still on to the case, he or she will have to come up with an answer for question 2. He will probably make something huffy up like, this is a statutory jurisdiction and I hope you're satisfied. Judge said that to me verbatim one time. Verbatim. Statutory. And in federal court, when the judge said that it's a statutory jurisdiction, the prosecutor threw the paperwork across the room. Thank you, Your Honor. Let the record of this court show that it intends to conduct a criminal action against me, use of bail, under statutory jurisdiction. But the problem is that I've never heard of such a thing as a criminal action under a statutory jurisdiction. I'd be happy to accept this, Your Honor, if you could please tell me where I can find the published rules of criminal procedure under a statutory jurisdiction. Most judges are likely to give up and dismiss the case here, but some might still be hanging on. If your case isn't dismissed yet, you might ask, do you have a copy of the rules of criminal procedure under a statutory jurisdiction in your office that I could borrow? Where does this nature and cause and jurisdiction information exist? Do you know of a law library anywhere that has a copy of these rules? Since I'm defending myself pro per, isn't your duty to specify which rules of criminal procedure will be used so that I may conduct a fair defense and a fair trial? You must tell me where I can access a copy of the rules. This is where you will win. The judge must either lie or dismiss. The truth is that they have just committed to a statutory jurisdiction, and there is no such thing, not to mention no official published rules to use. In some case, the judges will make faces at the prosecutor, and the prosecutor will motion to dismiss for some other phony reason. Either way, you win. This is what I'm coming in, I'm saying about, this is why I'm so hard on separation of powers for us to determine what kind of court that you're into. See diagram, alternate plan B. This is where the judge has actually answered truthfully back at question 2. And however unlikely this may be, you must be prepared to go the distance. The judge has now admitted that the criminal action will be brought as a condition of contract under the criminal aspects of an admiralty jurisdiction. Here's where you will be digging into the very origins of the fraudulent admiralty jurisdiction, namely the fraudulent international money contract that Roosevelt signed back in 1933. So picking it up at the third outcome to question 2, you would say, thank you, Your Honor. Let the record of the court then show that this court intends to proceed with a criminal action against me, use of bail, as a condition of contract under the criminal aspects of a colorable admiralty jurisdiction. Still not dismissed yet? Question 4. Your Honor, you must realize that no courts in America have admiralty jurisdiction without also having an international contract in dispute. And I'm not aware of having entered an international contract, so I deny that any such contract exists. Now, will you instruct the prosecuting attorney to inform this court that there is a valid international contract in dispute, if there is one, and to place this alleged international contract into evidence, if it exists, and explain how I can be a party to it, if I am, and how I'm compelled to perform under it, if I am. Somebody asked me, well, what do I do if they say admiralty jurisdiction? Well, I just told you where to go read it. I didn't make that stuff up. It's been in the patriot community for 20 years. What do you mean? Y'all not reading any of this? This is all bullshit that y'all are doing today. This ain't new. Let's keep going. This is an opportunity for the judge to bail out and let the prosecutor to go down in flames. Technically, it is the prosecutor who must prove jurisdiction once it is challenged. So now he or she is in a hot seat. At this point, the judge will probably dismiss, or the prosecutor will move to dismiss, or you may get a smart but foolish full historical explanation of admiralty jurisdiction from the prosecutor. This is the law of the sea. Like we don't know that. He or she might unwittingly spill the beans and get fired later because this is the big secret that they don't want the people to know. They can't afford to let us know that our country has been bankrupt since 1938, that the bankers own everything, and that we are held compelled to perform under an admiralty in default of paying off the phony debt that Roosevelt racked up. No problem. They're going down for the full count. If this happens, you can reply, fine. Let the record of this court then show that this court has declared that a criminal action against me, use of bail, is a condition of international contract under the criminal aspects of an admiralty jurisdiction. Now, Your Honor, according to the law merchant codes, the very law that this contract was made under, there are certain things that constitute a valid versus an invalid contract. You must realize that no court has the authority to enforce an invalid contract. And I deny the validity of the contract that Roosevelt entered into with the international bankers. He borrowed bank credit on the promise to redeem in gold coin, creating credit out of thin air. The bankers had no risk and no interest because they didn't loan anything of value and thus had no interest in the loan being paid. It was a no interest contract and thus void by the international law of nations. Therefore, America owes no legal debt. Now, I'm going to tell you what you do. You don't memorize these exactly the same way because they're watching this show right now. You put this in your chat GPT and ask them to rewrite this professionally. I'll give you an example. Can I copy it? I don't know if I can copy it. Oh, I know what I can do. I can screenshot it. I just screenshot it. All right, so we go over here, the chat real quick. Well, I know y'all gonna be mad at me about this. You attorneys looking. I'm gonna say rewrite this professionally. I'm gonna post it, paste it like this. Your Honor, I respectfully challenge the validity and enforceability of the contractual arrangement at issue. Under established principles of contract law and commercial law, an agreement must satisfy the legal requirements necessary for the formation of a valid and enforceable contract. A court cannot properly enforce an agreement that is void, unlawful, or otherwise legally defective. Accordingly, I dispute the premise that the financial arrangements entered into during the Roosevelt administration with private or international banking interests created an enforceable obligation in the manner sometimes asserted. If the transaction was premised upon the extension of bank credit rather than the transfer of gold, specie, or other tangible value, then the precise nature of the consideration of the parties' respective obligations and the legal basis for repayment must be established rather than presumed. I therefore respectively request that any party asserting the existence of such an obligation identify the actual contract, the consideration exchanged, the parties legally bound by it, the governing law, and the legal authority establishing that the alleged obligation remains enforceable against the United States or its people. My position is not that a debt may simply be denied by declaration, but that the existence, validity, and enforceability of any alleged contractual obligation must be demonstrated by competent evidence and applicable law. ChatGPT didn't watermark anything. What you mean watermark? I can copy this right now and put it in a thing. The thing is, why am I showing y'all all this? All right, I'm showing y'all this, and this is why we're doing the common law. All right, because a lot of people are confused about what the common law is. But I'm showing you all this because a lot of people, they'll say, well, they went in court and tried what you teach. What are you talking about? This has been around for like 2 decades before I came around. This was around like 15 years before I stepped on the scene. I ain't make up any of this. It's just that y'all are new and you don't know this. You don't know. I've been around 20 years. I didn't make up any of this. All this was introduced to me just like it was introduced to you. So please don't try to say, well, Yusuf, you taught. I don't teach a goddamn thing. What I'm teaching now that's mine is on SPC University. So you want to go over there and see what I teach, you need to come to SPC University and find out what I teach. But don't be attributing things to me that I didn't create. Now, I've used some of this and it's worked for me, though. I have used this and it's worked. I've used some things that's worked. Of course, the material is just scratching the surface. What do you mean it's just scratching the surface? Obviously so. What are you talking about it's just scratching? Okay, and this is what be killing me. You think it's scratching the surface, so you got some more information that you think that you know? Go ahead and put the information into the chat, because I'd be interested in seeing if this is just scratching the surface. Tell me what you know, because all we're talking about is bonds, creditors and their bonds. What else is there to know? It's about money. It's about jurisdiction. It's about rights and remedies. And it's about capacity. It's about capacity, classification, rights, duties, remedies, and liability. What else is there to know? Y'all try to make y'all come on here and act like y'all got so much secret information. Y'all ain't got no secret information. You know, you ain't got nothing. You whatever you gonna say, we done already heard. Guaranteed. We done already heard that shit 1,000,000 times. 1,000,001 times. I've been doing this 20 years. Trust me. I have not seen anybody I didn't seen everything from bonds, securitization, Bloomberg screens, CUSIP numbers. I didn't seen all of it. I ain't seen nothing. Your question, why depend on ChatGPT? Yeah, depend on ChatGPT. What is wrong with that? A lot of people do. What's wrong with you? It's a tool. I don't want to rewrite all that. I just rewrote 3 paragraphs of stuff in, 10 seconds. That's why I use ChatGPT. What are you talking about? This guy's stupid in there. You know, Agent Smith. You're like, what, are you stupid? Talking about why I'm using ChatGPT. I don't depend on, listen, sir, I've been doing this for 20 years. ChatGPT, I just started using a year ago. I can use ChatGPT because I got 20 years of knowledge to put into ChatGPT. I don't depend on ChatGPT so much. Everybody is using AI. If you're not using it, you're the fool, not me. I'm trying, let me ask you a question. Why are you not using ChatGPT? I use Claude too. Why are you not using it? That's why I want Agent Smith. Why are you not using it? So you think I learned everything from AI? Charge your body is not meant for that. I don't know what that means. Charge your body is not meant for that. I don't know what that means. I don't know what that means. I don't know what that means. And if I haven't given you permission to call me Joseph, don't call me Joe. Yusuf means Joseph. I don't know why you don't understand that. I've been saying that, but you don't, only people that I allow to call me Joseph, you don't have permission to use my government name. But my name is Joseph Jones. Ain't nobody hiding their name. I got a podcast called the Joseph Jones Podcast. You can call me Joseph over there, but you don't call me Joseph over here. All right? I don't give you permission. This is Yusuf L podcast. The Joseph Jones podcast is over on my other channel. So you're not doing nothing slick by trying to put my name. Yusuf means Joseph. It means God shall increase. Y'all stupid. And the survival guide doesn't say the difference between pro per and pro se. I don't know. Why don't you go read it? I don't know. I don't know. I don't know. Did you read it? Did you go? See, this is what I'm talking about. He's asking me a question. He go there and download the document and read it himself. He can upload the entire document to ChatGPT and ask the question that he just asked. That's what you would use AI for. I upload the document and say, this document, does it tell you the distinction between pro per and pro se? Just put it in chat. I don't know. You go read it. I'm not going to read it for you. Go read it. That's the problem over here. Y'all don't want to read anything. I've been saying this right here for 20 years. I came through the door talking about all of this, and nobody reads any of this stuff. They don't read in it. They don't read in it. In the begging, I swear it says in the begging, or are you trying to say in the beginning? Okay, well, don't ask me what it says. I don't know. I don't read it. I haven't read that document in years. I'm just telling you where the information came from, dude. Okay, you can do whatever you want with it. You can put it in ChatGPT and analyze it, like I have. I've analyzed all these documents, okay? That's why I have different things now that I'm teaching, because that's why I'm giving you all this, because it's old information. It's old and outdated information, pretty much. But it does have some basis and foundation. And if you understand the foundation that it's based off of, then you can update your information. But y'all can use, that's why I just showed you how to take something and rewrite it in ChatGPT. You can learn this yourself, man. Y'all be killing me, man. Dude, come on, all of them. This dude came on my Instagram today talking about some shit I ain't taught like in 7, 8 years. And he's still mad about some shit from 12 years ago. about 12 years ago. It's not coming all on my live, man. Don't come on my live doing that. I'm showing you where the information came from. I've been saying the same thing. I've been saying the same thing for 20 years. 20 years. I made videos that y'all can read from. You are responsible. If you don't want to come to SPC University, I tell you where to go and get you some stuff. I just show you. Go right over here. You go right over here. Where is it at? You go right over here on this right. You can download all these documents, and you'll get a pretty good, solid education right here. You don't have to pay anyone any money or anything like that. You go right here. They could download them, all of them. They're downloadable. It's still available. That's the old creditors. This right here, I had somebody rewrote this. Do not use this creditors in their bonds. This is a trash. Dude, it's full of spelling errors. It's almost like dude intentionally tried to trash this document. This is not the creditor in bonds you want to use. You do not want to use that. I do not use that. That is a trash creditors in their bonds. That's a very deceptive document. Do not use that version. Go to SPC University and get the version I got over there. All right, and then you got dealing with presentments. Oh, right here, dealing with presentments. Let's look at this right here in chapter 4? Redemption in court. Let's read this real quick. Redemption in court. The redemption dialogue makes the court proceeding into a deposition that you are conducting for the purpose of establishing on the record who the claimant is in the case. You are there under threat, duress, and coercion, since guaranteed harmful repercussions are inevitable if you do not appear when or as commanded. You're also here because someone somewhere has made a claim or color of claim, implying or calling what they allege without foundation a claim against you that allegedly justifies enforcing the claim against you by using the legal violence system. By engaging in this deposition, you are actualizing the maxim of law that the burden of proof resides on him who asserts, not he who denies. You want them to prove the nature and cause of their alleged or implied claim. In other words, you as the creditor, owner of the court, and both sides of the transaction are requiring them to put up or shut up. When you go into the courtroom like this, you are exercising your rights under public international law to determine what kind of business these people are trying to do with you. In any exchange between you and the judge, whether it is you requesting the judge answer something you're asking him or him asking you a question, you must persist until the judge sees that you're not going to give in. This is perhaps especially important if or when a judge asks you to state your name or ask if you are so-and-so. He may ask at least 3 times since the system functions in threes. The judge needs to know that you are clear and secure about what you're doing. This is all the esoteric stuff. This is why so many people lose with this. Because so many people into this, they can go in and say magic words and the judge will just automatically do what they want to do. They don't understand that they have to contend with the judge and that the judge is going to be deceptive with them and things. They're not prepared for that psychological attack that the judge is putting up against them. And that's why so many people leave in throes and say, well, that didn't work for me. Yeah, it didn't work for you because you didn't study it. You just went in there and regurgitated some shit somebody told you to say. It goes on, it says, the judge needs to know that you are clear and secure about what you're doing and will not cave in under the psychological pressure that he is so well trained in applying of those who are before him in court. Likewise, you may have to state your request 3 times until you receive either an answer, a non-answer, which stands as an admission on the record of your position in the matter. The first thing you do is when you go into the court, the first thing you do is to ask the judge for his name so the record is set concerning the parties entering into the agreement. Therefore, when your name is called, you say, I'm here concerning that matter. May I have your name, please? Everybody say, I'm here concerning that matter. Nobody asks the judge for their name. You get on the YouTube videos right now and see people try that. You won't find one person that will ask the judge to state their name. I saw one old video where a white man did it, but it's probably about 20 years old. Because they'll read this. Pay attention to the fact that most judges or justices prefer to give their title, not their name. If the judge gives his name request, would you please spell that for me? If the judge gives his title, such as Judge so-and-so or Judge Smith, you can request, your awful communication is accepted for value and your dishonor is returned. Please state your name, not your title. When you're asking for their name, the reason why is because you are a private man and you're trying to speak to him in his private capacity. You're not speaking to him in his public capacity. All right, when you go down to the Secretary of State and you get their judge's oath of office, it doesn't say Judge so-and-so, it has their name on it. If you've ever taken the time to go get a judge's oath of office, so you're asking the name because you're entering into a contract, because these are courts are places of contract. Don't they ask you agreement? You got to have a stipulation with the prosecutor. When they put you on probation, you got to sign a contract. When you go to jail, they make you sign your name. What you mean it's not a contract? If the judge states that his title name, you can ask, is that Judge so-and-so the same Judge so-and-so that's registered with the Secretary of State? They don't like that question. Now, if the judge won't give his name, then go ahead with the second request anyway. If someone with you are dealing in court fails to respond or is standing mute, it means that you're in control and he's waiving his rights. Request number 2, do you have a claim against me? That's a powerful statement to say in court. Every time I've said it, they get quiet. Do you have a claim against me? Do you know anyone who does have a claim against me? Okay, now we know also that I just showed you the other day, like in Georgia, OCGA 1711-1, when they find you guilty, they put a lien against you. That's a claim. So I request that the honorable judge direct the prosecutor to provide the assessment for the charges along with a certified audit trail of all transactions, including voucher, as well as all disbursement documents and receipts. Where did I get that from? Right down here. Do you know anyone that has a claim against me? Right here. I request the title, Judge, please direct the prosecutor to answer whether the assessment for the charges is in his possession. I request that Judge so-and-so direct the prosecutor to provide the assessment for the charges along with a certified audit trail of all transactions held by the mayor or of the municipality and the applicable risk management department, including voucher, as well as all disbursement documents and receipts. You can see I committed all this shit to memory 20 years ago. This is where I got it from. I didn't write this shit. Nobody knows who wrote it. He didn't put his name on it. Which you're going to find most of the most powerful documents that I have ever read, they won't put their name on it. Which lets me know it's somebody on the inside writing this information. Because I used it and it went just like they said. We ain't doing that dumb shit out there that y'all thought, you ain't got jurisdiction over me. Ain't nobody saying that. Nobody has ever taught that. There's not a single document that I'm presenting to you tells you to go into court and say you don't have jurisdiction over me. That's echo chamber bullshit. Echo chamber. I don't know where they got that shit from. Gene Keaton tell you right here, he said people going there. Let me tell you what I read when I first started. It's Gene Keaton right here when he was talking about it. Where's that Gene Keating transcript right here? These are all the documents I had when I first started. The very first time I started learning all of this, this is what I was reading. I'm talking about 20, 25 years ago. When I first started in this, this is what, you can see this right here. It was written in what, 2004. 2004. He said, if it's in there, that is why all these guys, right here, he said, that is why all these guys are sitting in prison wondering what's going on. If you go in there and argue jurisdiction, Jack Smith is exactly correct in what he is saying about honor, dishonor. If you go in there and argue jurisdiction or refuse to answer questions that the judge or the court addresses to you, they'll find you in contempt of court and they'll put you in jail. And if you read clerk's practice, that's all they talk about is contempt. Why are you going, why ain't nobody been teaching this shit that y'all talking about on the internet? We've been talking, they've been teaching against this for over 22 years. You don't have to pay anybody any money. You don't have to pay me $99. You can go right over here and you can get a thorough foundational education. And then you can come to me for clarification if you want to, because you're not going to understand all of this stuff. It's going to take you to go all this stuff. It's going to take you at least 3 years to be functionally literate with what is being discussed in these documents. They have nothing to fear from you. All right, you're not going to commit all that stuff to memory. You'll commit a goddamn rap song to memory, but you're not going to commit this shit you need to say in court to memory. But you can do NBA Youngboy, you know, got all goddamn 17 of his songs by memory. But you're not going to memorize this right here. That's why I do my videos to a beat, because I said, let me put a beat behind it. Maybe they'll try to memorize it if I put a beat behind it.